Welcome back. Now, the Henry Segura case is on break, so we're going to take a little bit of a side turn here and talk to Wade Fink. Now, Wade Fink is the attorney for Siwatu, Salama, Raw. I'm not sure if many of you have heard about this case, but she, along with Mr. Fink, had won their appeal, overturned her conviction of assault with a weapon and felonious possession of a weapon. She is now released. Pending the appeal, she had a GPS tether on her. Wade had won both arguments as to overturn the conviction, releasing her, no GPS tether. I mean, I don't want to talk too much about it because I really want to jump in with Wade and talk to him about it. Wade, welcome to the Law&Crime Trial Network. Thank you for joining us. I've got so many questions, but first, just tell us about this story, please.
Very grateful, Brian, that you would have me on. It's very nice to meet you. Thank you for your work as well, and I appreciate you guys putting sunlight on this case. Siwatu Salama Ra, my client, is a wonderful human being and a huge contributor to this community here in Metro Detroit and in Detroit itself. She's a community activist, a leader in environmental justice reform. She is respected by her peers and in the community, and we're very lucky as a community to have her. She found herself in a situation, unfortunately, where she was faced with the threat of violence from a 3-time felon. Her family and her were faced with the threat of violence. She's a lawful gun owner. She had a CPL, a concealed pistol license here in Michigan, and she brandished that weapon, which was unloaded at the time, but she used it as a deterrent to fend off what she viewed as an attack on her and her family. And unfortunately, for reasons that I wish I could go back and change. I wish I was the trial counsel the first time around. She was convicted of a felonious assault and a felony firearm. That carried with it a 2-year mandatory prison sentence. And she unfortunately was 7 months pregnant at the time and was unable to get a bond. She gave birth in prison. When she hired me, we acted as fast as we could to try to get her a bond pending appeal. And eventually we were successful in reversing her conviction. And now we are at the situation where we're trying to figure out what the prosecutor's next step is going to be. Are they going to retry her, or are they going to let this go?
So, from my understanding, today was supposed to be the day you're supposed to find that out, and it seems like the hearing has been pushed back. I got to watch some of your arguments in court about I think you kind of described them as hurdles that the prosecutors are kind of putting in place. And you were very vigorous in saying, hey, man, like either get the hurdles out of my way and let's start this trial or figure out what you want to do. Can you kind of talk about those legal impediments and those hurdles that you're facing in this case?
Sure. And that's been my biggest frustration. So I appreciate you asking me that. Look, this case has been going on for 2 years, and it took on a life of its own in the media. And when the conviction happened and we had a trial judge unwilling to let her give birth before going to prison, someone with no criminal record who had showed up in court every day in the face of a 2-year mandatory sentence, to not allow her to give birth for not only her sake, but her innocent child's sake before reporting to prison was an absolute tragedy and injustice. And when that happened, it got a lot of attention, both locally and nationally. So the prosecutor's office, my point in telling you that the prosecutor's office knows this case. They know it quite well. And when we secured her release, which they resisted initially, and when we secured her reversal of her conviction, they basically shut us out of the process for 56 days. That's the amount of time it takes for the appeal mandate to be final. And didn't tell us if they were going to appeal to the Michigan Supreme Court, if they're going to retry the case, or they're going to let it go. So you let a woman who's already been punished with 9 months in prison for a crime she's innocent of, who gave birth in prison, you let her have additional emotional trauma of unknown for 60 days. And now they're dragging their feet again on deciding what they're going to do with this case. I remain hopeful that they will dismiss it. But if they don't, we will try this case and we will get a not guilty verdict.
I want to ask about, from my understanding, and like you said, you weren't the trial attorney, the prosecution, to their credit, at some point, I think they actually asked the judge to allow Ms. Ra to have the child outside of prison. Is that correct?
Yes, they could have done more. What they did agree to is she's not a danger to society, which is one of the conditions of bond and release. They wouldn't concede at first, before I came on, that there were legitimate appeal issues, which they could have done if they truly want to see a release at the beginning. But I will give some credit where it's due that through some of this process, they didn't put up too much of a resistance, I'll say, to a bond pending appeal and let the judge finally make the right call. It took a reversal, actually, even without their resistance, to get her out on a bond pending appeal. But I'm hesitant to give too much credit given how this is now going, and we're still dragging our feet and not making a decision and letting this woman either get on with her life or let's try this case. I think they know that now that some decisions have been made, the right instructions will be given, cross-examination will be more fair, that the outcome of this case might be a lot different.
Wade, trust me, as a public defender, you're preaching to the choir in that one. But you talked about the right instructions. Now, my understanding, please correct me if I'm wrong, the Court of Appeals in Michigan did two things as I kind of read them. One is saying that self-defense charge should have been given. I understand in Michigan, so long as you put forward some evidence, you're supposed to get that charge. And that charge wasn't read to the jury, so they couldn't consider self-defense, either of themselves or to Siwatu's child who was at the scene, as well as her mother. The other thing that I kind of read, and maybe I'm reading too far into it, I think the Court of Appeals said that what she did was reasonable. Now, they didn't really go into whether or not this was self-defense, but my question for you is when the Court of Appeals kind of does that, do you take that as kind of like a wink and a nod, like a little, hey, maybe it's self-defense? Does that give you like a little bit of a fire to think, hey, this really is a self-defense case, the Court of Appeals is kind of agreeing with me, and I'm going to go full force in?
Brian, I have been trying to be as cautious with my words as possible because I've been hopeful for so long that the prosecutor's office is finally going to see this the right way. But the delays and the constant indecision is making me less and less cautious. There is basically a handful of people compared to thousands who think that this is a crime occurred here. The Court of Appeals said pretty flatly, as you just noted, that had the correct instruction been given, the outcome likely would have been different. That is a pretty strong statement, and frankly, the Court of Appeals, in order to reverse, to find something wasn't a harmless error, they have to find that. So essentially, the Court of Appeals, like you just said, is more than a wink and a nod. They're saying, with the right instruction, this case would have been different. And I'm gonna, if you'll let me, Brian, I'll break some news on your show.
Please.
A couple days ago, I received a call anonymously from one of the jurors in Siwatu's case. She's beside herself. Having read the news articles, she's deciding whether she wants to come forward and write a letter. I have let the prosecutors know who I think it is based on process of elimination, but keeping her name, or I'm sorry, I let them know that I think she is who she purports to be, a juror, based on the information she shared with me. But she is beside herself because if they had given that proper instruction, she said that the jury deliberations would have gone a lot different.
Wade, I appreciate you for coming on. I appreciate you for not only giving us that little insider scoop. I'm hoping we can get back in touch and have you back on again. And at least this host of this network, and I believe everyone else, is going to be watching every step of this as you just continue with win after win in the post-conviction and appeal phase. So I wish you all the best, and thank you.
Brian, I'm grateful for two things, not only the time on this show and the sunlight, but also for your work as a public defender. That's some of the highest calling as a civil servant, so thank you.
Thank you very much. Have a good day.
You too.
As we continue, we're going to go back and look at the Hammer and Segura case. Of course, we've got live testimony after their lunch break, but we're going to come back after our own break and look at some of the recaps in the Hammer and Segura case.